I'm William Deveneau, and I'm an estate planning attorney. Today, I'm going to talk to you about how to contest a will. There are specific grounds under which you can contest a will. First, to contest a will, you need to have standing. But what does that mean? Standing means you have an interest in the case. To have standing, you need to be an interested person to the will. An interested person would be an heir at law, such as a son, daughter, spouse, or a beneficiary listed in the will, which could be anybody. It could be a charity, could be a friend. If you're listed in the will, or if you're a relative that would be an heir at law, you're an interested person and you can contest the will. When you're first notified there's a will at probate court, there's a certain time limit you need to respond with. Because if you don't respond, they will just assume that you're consenting to the will. So if you have standing, you need to timely file your contesting of the will. Now, on to the grounds to contest a will. There are four main grounds to contest a will. First is it lacks legal formalities. For example, if the state requires 2 witnesses to a will and there's only 1 witness, that's a problem. That's an invalid will because it doesn't meet the legal formalities of what a will needs to have to be valid. The second one is the testator, who's the person making the will, lacked mental capacity to make the will. This could be somebody that has dementia and is just writing things down, and it may meet the formality of a will. They may have signed it, there may be 2 witnesses, but they don't have the mental capacity to make the decisions they did in the will, so they can't execute a will. You need to have capacity to write the will. The next ground for contesting a will is undue influence. Now this is a little bit more complicated. I'm going to get into undue influence in a future video, but basically it is when there is some sort of influence on the person and it unduly influences them to the point where this will is not a reflection of their true desires. There's some outside force coming in and making them create something that really isn't their true desire. It could be something where at the time they may say, this is exactly what I want, but there's some sort of pressure, there's something that's making them do this, and in all reality, it's not their true desires. The final grounds to contest a will is fraud. The most common time when fraud comes up is when someone that's in the will now, a new beneficiary, says something to the testator, the person writing the will, and the statement that they make to them is false. And because of that false statement, the person writing the will changes something in their will. That is an example of fraud in the will. As you can see, these are some pretty specific grounds you can contest under, and there really aren't any other ones. And you need to have standing to contest. If you know anybody that wants to contest a will, you should share this video with them so they understand the basics. Because you can't contest a will simply because you don't like what you got or you think you should get more. That's not a reason to contest a will. It'll be thrown out as that's not a grounds to contest it. But if you know anybody that wants to know more information about contesting a will, share this video with them. Comment below, send me questions, and have a great night. I look forward to sharing more information with you.